Guardian and Berkshire disability lawsuits have a special spot in my heart. They're always difficult. Guardian fights them tooth and nail, no matter what it is. If they've denied a claim, they think they're right. And I've rarely ever encountered something with them where they go, after we sued them, I think we got this one wrong. And so either it's a level of arrogance or confidence on their part, or they just think they're never going to make a mistake. So maybe I'm being a little hard on them. It's just my personal experience. I've only seen thousands of their denials, and we win a lot of appeals against them. But when it comes time to lawsuits, it's a heavyweight fight, and that's just the way it's going to be with them. But it's a fight that we take on no matter how big they are, and we've done it all over the country. But the people who are watching our video now want to know, what should I expect? And I want to skew towards ERISA type claims, the group ones, because if it's an individual disability, that's your classic lawsuit where you're really going to get your day in court. We're going to do depositions, we're going to do interrogatories, we're going to do discovery, we're going to talk to every single witness there is, and then we're going to go to trial, we're going to have a jury trial, and you're going to take the stand, and all your doctors are, and we're going to present everything, and the jury's going to make a determination. And everyone kind of understands that because they see it on TV every day now, right? These types of civil lawsuits. But in the world of ERISA, it's not like that. It's not a level playing field necessarily. It's not what anyone expects. It's not the glorious, I'm going to go in there and I'm going to stick it to Guardian and I'm going to get to talk and the jury's going to hear me and feel me and believe me that because every claimant believes their stuff. They're not just not wanting to work, but not like that now. So, Stephen, I want you to explain, what is this ERISA lawsuit against Guardian all about? Why do I always talk about and go around the country talking about this and always on our videos say it's the wild, wild west?
Well, it's supposed to be a standardized area of the law, but for every opinion you can find in your favor, there's one that counters it, right? So that opens the door for a lot of various different things. But I think when the experience of what to expect, there's two parts. There's what the client's going to personally experience, during the litigation process, and then I think the understanding of what the litigation process looks like. So, the statute that govern these, ERISA, it's federal statute. So these lawsuits are filed in federal court. You have no state law causes of action, so you can't sue them if it's available in your state. Bad faith, punitives, extra contractuals. You can only sue them for unpaid benefits. You don't get the right to a jury trial. It's just a federal judge. You don't testify. Your doctors don't. No one from Guardian does. And as a default, standard review for the court is going to take a look at Guardian's review, through the start of the claim and then the final denial. After a final denial, there's nothing new a judge can consider. And that judge is in a lot of ways, it's almost like doing a second appeal, because that judge is doing an appeal, a review of the review done by Guardian. And a two-step process. One, did Guardian get it right? Are you disabled? Now, obviously, if they say, Guardian got it right, we don't find there's enough for disability, case is over. But if the judge does find that there is enough to support disability, goes to a second step, and that is, did they act arbitrary and capricious, or, did they have a reasonable basis? So it creates a situation where Guardian doesn't have to necessarily establish they made the right call, just that based on everything was a reasonable conclusion that they reached. So it's a threshold that's a lot easier for them to meet. You don't go into litigating these cases on an even playing field. The insurance company does get the benefit of the doubt. And then, with discretionary clauses and policies too, some people say, well, this is a contract. When you think about it, yes, but the way that courts generally have to look at this, they have to defer to Guardian's interpretation of their plan, not how you interpret what terms mean, but what Guardian does. So it really sets a situation where Guardian's going to get the benefit of the doubt. And then, like I said, you only consume for unpaid benefits. If you win your case, the only guarantee you have is they pay you the money they owe you to that point, and the judge orders they put you back on claim. There's no guarantee of future benefits, or they won't mess with you again. There's a possibility of attorney's fees, but Guardian, I think, approaches this with their mindset of, we think, like you said, we did the right thing, that we're infallible in our decision making. But even if we're wrong, our worst day may just be paying them the money we owe them. So there's really no financial disincentive not to act aggressive in denying.
That was a great summary of how it goes down, and I think when people hear what you're saying, there's often a rewind in the middle of watching this to say, did you say there's no punitive damages, there's no compensation for them putting me in a position where I couldn't pay my bills, I couldn't afford my medical records? There's none of that. There's none of this verdict I'm going to be able to get to say that they should be punished. There's no deterrence factor available whatsoever, and it's horrible. It's one of the worst parts that I hate about an ERISA governed claim, because the claimant can only get their benefits, and then maybe as a prevailing party at the discretion of the judge, which is often granted only, again, if you win, would be attorney's fees, which helps, but the claimant's been through so much. They're 2 years down the road, so it can be a long road, and you get what you're supposed to get, and it's kind of like Guardian goes, sorry, we made the wrong decision. But Caesar, in light of what the outcome is, and that you don't win, like Jessup said, future benefits or anything, you just win, you're back, and then you're back on claim and you have to deal with them. Talk about what a win could be, what that means in terms of a case, because a lot of these things end up in settlements and people don't really understand what is that all about.
Sure. Well, obviously you have the win, which you win your back benefits, as Steve was mentioning, and that would be from whenever they either stop paying or if they'd never paid any of your benefits at all, up to the point of judgment. And like you said, no future benefits. So if you are in your mind thinking, well, the judge is really going to stick it to them now, and if we win, they're going to see how terrible Guardian is and now tell them and force them to pay my benefits ongoing. Well, what they're going to tell them is, you owe them these benefits up to this period of time. Now we're going to send this back to you to consider if they're entitled to ongoing benefits. That's the remand. Then there's obviously you lose. And if you lose and Guardian wins, then there's no recovery of anything. The alternative to that, either of those scenarios, is the compromise, the settlement. And that could come in different ways. It could come through a mediation where the court or the parties, the court, ordering the parties to participate in mediation. Why would a court do that? Well, it takes the decision out of the court's hands. It takes it out of the judge's hands. The judge doesn't have to spend hours reading through these briefs, reviewing the administrative record and the evidence, and discussing it with his law clerks, and trying to draft a very well articulated, reasoned decision so that they don't get appealed to the Circuit Court of Appeals. And the parties ultimately live with whatever that decision is that they've reached in that settlement, through a mediation. Court's ordered it. The other is obviously the parties just agree to it. They say, all right, well, without the court ordering us to do this, we're just going to see if we can come to the table and reach a resolution. And sometimes it may not even require a mediation. And it may just be the parties, or through their lawyers, engaging in settlement discussions and resolving it. Does it make a difference in how much you potentially recover in the settlement? It could. It could. It come down to timing. It could come down to the type of mediator you had that was, perhaps influential in the negotiation process. But one thing that is affected is timing, right? Timing. When does the mediation occur? Usually it occurs over a day. Sometimes, and I know Steve recently had a case where the mediation was continued. And it's not that they are saying, hey, we couldn't reach a settlement. They're just saying we couldn't reach a settlement today, but we're going to keep talking, and we're going to try to work out some of these other issues and see if we can get this resolved. And then obviously, if it doesn't settle, either at mediation or before mediation or after mediation, and the court's going to, review the briefs, they're going to review the law, they're going to be the ones who weigh the decision and make it.
Well, what I like to tell claimants to let them know is when they contact us and we review their denial letter, and then sometimes we need the claim file before we even accept their claim, but more often than not, we're going to know right away, do we think you have a case that's worth even filing a lawsuit on? Because we probably reject more cases than we accept because the case law is tough. So we're going to have a conversation with the client and be like, look, here's, just based upon what we see here, here's what we think are your chances of winning. You could have someone that has a 25% chance of winning, and it still could be a case that we're going to take, but we're going to say, this is the range with probably 85-degree level of certainty. Guardian's going to offer you this amount of money. And if that's something that you think is reasonable, we're willing to move forward with you on that particular case because there's risk to Guardian. There is almost no case where it's a guarantee where Guardian is going to sit across the other side of the table from us and go, we are winning this 100% of the time, you have no leg to stand on. So there could be money there. But if your chances of winning are 25%, you probably don't want to go forward with that case, but you still want to try to maximize to get something out of this particular case. So we take a very practical approach with our clients. We're not one of the law firms that's going to just be, yeah, we're going to win your case and then get down the road and you get 5 cents on the dollar and you go, why did you waste my time? We don't want to waste your time as the client. We don't want to waste our time. We want to really try to maximize every dollar we can, but within a degree of reasonableness. We would love to crush Guardian on every single case, go to a verdict, get a big attorney fee award. More often than not, the attorney fee award is going to exceed potentially what we can recover, but that's not our business plan. Our business plan is to get the benefits paid for the client as quick as possible. That may be get your benefits reinstated. More often than not, it's a lump sum settlement. But what you do get when they call you, Jessup, any of our lawyers here, we're going to let you know right away and be able to tell you within a matter of 30 minutes, this is where we think this case can go. These are the potential ranges of what this case is worth. You're going to get an honest and quick opinion. And the other thing that we want claimants to know who are watching this is we have been there, done that with Guardian many, many times. And as soon as our name appears on your particular file, they know this is a firm that if it's got to go the distance, it's going to go the distance. And they have all the resources, all the skill to get that done. And that's what you want as a claimant. And because of that, you're going to get more value. So you may find a firm that's going to charge you a couple dollars less, but the offer is never going to be near the level of what we're going to get. So something that things need to talk about. So what I want to encourage you to do if you're someone out there, give any of us a call. We'll review your denial letter immediately. We'll set a free phone consultation. And no matter where you live in the country, we're available to assist you.